People of the State of Michigan versus Levon Thurman, docket number 18-731FH. And this is the time set for sentencing. Mr. Thurman, you were convicted of 4th-degree criminal sexual conduct. That is a felony punishable by up to 2 years in prison. And you have the right to be represented by an attorney. You are represented by Mr. Samuels. Pardon me, it's technically called a misdemeanor, but it is punishable like a felony up to 2 years in prison. You're represented by Mr. Samuels, who is present in the courtroom. And Mr. Samuels, have you had a chance to review the pre-sentence report with your client?
I have, Your Honor.
Do you have any additions, deletions, or corrections?
Just one major one. I think I'll defer to Ms. Polder for that one.
Actually, I have one on the cover sheet. Maybe that's your major one, is it?
So our concern is when we came for the plea back a couple of months ago, the parties had agreed that the defendant could qualify under the HYTA status. And because the criminal sexual conduct in the 4th degree, based on a force or coercion theory, did not qualify under HYTA, we had to change around the conviction to where we both agreed that the final conviction would be attempted felonious assault. So I have prepared a second amended information for that, and we can change that on the record. I believe it's via stipulation. It was something that I informed the court way back then on, and I know it's been a little while, and the court asked me to wait until today to correct everything.
Okay, yeah, and everything that's happened since then, honestly, I've forgotten all of that.
Yes.
But,
so I have the amendments. I can pass those out now.
If you would, please.
And just for the record, that's the same 2 years punishable by 2 years.
And then did you say, was there a stipulation or?
It was a stipulation to have the conviction entered to the count 5 on the second amended information, which is attempted felonious assault.
But I mean, did you do a written one? I can't remember.
Oh, no, I'm sorry.
Okay.
But I don't have any objections to that.
Okay, more important though is your client. So can you slide the microphone over to Mr. Thurman? So Mr. Thurman, I assume your attorney explained all this to you, correct?
Yes, ma'am.
So what they're doing is you pled to the 2-year 4th degree criminal sexual conduct that, like I said, is technically called a misdemeanor but punishable like a felony. And now they're saying that instead of that, your conviction would be to the count 5 attempted felonious assault, which is also then punishable by up to 2 years, which is also technically called a misdemeanor but punishable like a felony. You understand all that?
Yes, ma'am.
And you know, I think I would have to take a factual basis again because it's different for felonious assault.
I thought the factual basis was still being able to be laid out.
Felonious assault is an assault with a dangerous weapon.
We entered the original factual basis to the underlying
Under the court rule.
Yeah.
Okay.
Okay.
So, Mr. Thurman, is this okay with you if they switch the convictions, which makes you eligible for YTA?
Yes, ma'am.
And does it change anything about what we talked about back when you pled guilty? About, you know, you understand you're giving up your rights, you understand the maximum penalty, you're doing this freely and voluntarily. Is that all true today?
Yes, ma'am.
And you want to go forward then with the sentencing?
Yes, ma'am.
Okay. Then I will vacate the conviction on the count 4, 4th degree criminal sexual conduct, and a conviction will enter, or not a conviction, but I will accept the guilty plea because it is an agreement to YTA. I'll accept the guilty plea under count 5, attempted felonious assault, punishable by up to 2 years in prison, a misdemeanor. And then we have to make a number of corrections to the pre-sentence report.
I have those changes now, Your Honor.
Good. Do you want to take them then?
Sure. The first change would be under the final charges in the boxes. The MCL is 750.82 bracketed A. I've crossed out all of the language next to it indicating criminal sexual conduct 4th degree, I've inserted attempt felonious assault.
Okay, can you give me it's actually a PAC code. Can you give it to me again in full?
750.82 bracket A end bracket.
I'm sorry, thank you. And then I crossed out the sexual conduct and I'm putting in attempt felonious assault.
Yes. The plea agreement will be defendant pled guilty to, and then I've crossed out orally added count 4. I replaced it with count 5.
Okay, and I had already changed I changed it to Killebrew agreement to YTA.
Okay.
People will dismiss counts 1
Through 4.
Got all that.
And then I've crossed out the entire last sentence of
Yes.
if YTA is granted.
Yes. Got all that.
Okay. Next change is in the convictions, which is page,
Well, there's more changes under evaluation and plan, but I'll take care of those. They're consistent with what we just talked about on the cover sheet.
yes.
And I have no objections to that, please.
The current conviction, under the criminal justice section is just the change to the final charge.
Got it.
And that's my only changes to the body. I would just have changes to the guidelines.
Well, the BIR is going to change. But it's all sort of clerical changes that are consistent with everything we've done, so I'll take care of that and resubmit it. So what was your next one?
I just have sentencing guidelines, Your Honor.
Sure.
I have offense title changed and the class is changed to an H class.
Okay.
And then my only changes to the guidelines are to OV 13, should be scored at 0 points.
Okay.
Changes the total OVs to 65 points. It does not change the level.
Do you agree with those changes?
I do,
Mr.
Your Honor.
Samuels, okay. Oh, now we need the microphone back to you, actually. So no objection to changing the guidelines as Ms. Polda said.
That is correct, no objection.
Thank you.
So the total OVs is 65, it's a level 3, and it changes the range to 0 to 6.
No objection to that as well.
It's a level 3, it was a level 3.
The class H is,
Oh.
yes, it's, the range is higher.
Got it, got it. All right, so I've changed that, and it's now under the Class H guideline grid, it is a level A3, and the range is 0 to 6 months.
Yes.
Got it. Is that it for changes then?
Yes, thank
From
you.
both sides, we're all
That's
good?
all my changes.
Okay. Now, is there a victim who wishes to be heard?
Yes, Your Honor, we have Marissa Gatkatru, she's here in the courtroom, and you want to come up here and make a statement for the judge? Yeah.
Would you like us to stay here?
You're good.
You could sit right here, or right here.
All right, and could you just, for the record, state and spell your name, please?
Yes, Marissa Gatkatru, MARISSA, GOTTGETREU.
Thank you. Go right ahead.
Okay.
Take your time.
Okay. So I would just like to start off by saying that I am thankful for being here today, to be able to be here, that I am in a better head and mind space than when I was 2 years ago, especially the last time I was up on the stand. So the night of February 11th, 2018 was not just another Saturday night for me. Months before this night, I was forced to get a second job to survive after a breakup. I spent months and months working every opportunity I could, upwards of 20 hours a day. That night was finally a place where I could go out and be a normal 22-year-old, to have fun and to hang out with some old friends from high school. Fast forward to 2 years, well, over 2 years, excuse me, I have felt like I haven't had a voice, that my life is not in my control, that I don't have a say in it. So this is me having a say and having a voice. And I'll share what the night of February 11th has done to me, not to be labeled a victim, but for accountability. I've spent the last 2 years trying to get back to a place that I was at before that night. I have worked very hard to build confidence and to get over my anxieties that used to be very debilitating. All of that reverted back after that night. I've lived every single day in fear and anxiety. Simple tasks of going to the store would require a pep talk. A workout at the gym that used to be my solace would either end in me leaving before I even entered, or talking myself through the whole thing, trying to calm my anxieties. A simple hug upon first meeting turned into now one of the biggest warning signs I have ignored. I've always been one to see the good in everyone, to not judge, to not think anyone has ill intentions. That night proved me wrong, which I would later cause, again, massive anxiety. I couldn't see strangers. Being out in public was massive anxiety. I just wanted to hide away from everything and everyone. Because of that night, I will always question anyone's intentions. Because of that night, I lost a job, self-confidence, due to anxiety and depression. I lost my job because there were some days that I couldn't even take care of myself. And as a caregiver and a hairstylist, I can't take care of anyone else if I can't take care of myself. Because of that night, the fight for my dream job doubled in stress and length of time. Through this whole process, I just wanted it to be done and over with. I was tired of it affecting my life and constantly having to miss work, which again, my dream job as a hairstylist. All the hearings and the trials that kept getting pushed back, each time I would relive that night. I would like to add, every single time that it was pushed back or re-adjourned was due to the defense's side. All of the mental stress it caused and the constantly affecting my work and my dream. Now that this day has come, I've realized I will never be done and over with this. I may not be forced to relive it anymore, but the damage that it has done to me personally, I will have to deal with every day of my life. Every day will be a fight. Having to live with the fact that someone took advantage of me in a situation where I was not able to defend myself for their own personal gratification. And many who do know me know that if I don't want to do something, I am very well at defending myself. All I ask today, Your Honor, is that all of the stress, all the anxiety, all of the torment that I've gone through the last 2.5 years, all I ask is that you give him the proper sentencing for everything that I've gone through. If this was your daughter, if this was your niece, if this was your cousin, because the charges he was facing before are nothing what he's getting today, in my opinion. So the attempted assault, I'm just very glad that there's at least some type of justice. There's some type of accountability. And I guess that's all I have to say.
Thank you. Thank you for being here and for your comments.
Thank you.
And did the people wish to be heard?
Thank you, Your Honor. Marissa did say it best when she explained how this has affected her. And when the prosecutor's office has to make decisions regarding the outcome of a case after we already had one trial and it came back as a hung jury, Those are difficult decisions, and there's a lot of things that we have to weigh. I wish it could have been different for her. I wish that this could have been resulting in a conviction after the original trial. But what I'm hoping here is that having a plea entered without having to put her back up on the stand to have to relive that entire event again in front of strangers is some kind of solace for her, at least. But in this circumstance, it also puts that conviction, puts that admission on the defendant, where he was able to get up in a public court and admit to what had happened and what he did. As Your Honor likely remembers from the trial, Ms. Draganchuk had described her state of intoxication being so severe that she was vomiting continuously in the bathroom, and he immediately puts himself onto her. He immediately penetrates her while she's in the bed. He had no concern about anyone else but himself on that night. He had no concern about her well-being, whether she was consenting, nothing but himself. And to read this pre-sentence investigation report and to see that he has a daughter, it makes me wonder how he would react if he found out somebody was doing that to his daughter when she was in that type of a state. So, Your Honor, I know that you have quite a bit of background regarding the actual facts of this case because of the original trial, so I would ask that you sentence as you feel appropriate in this matter.
Thank you. And Mr. Samuels?
First off, there is an agreement for HIDA, and I think that HIDA is appropriate. This young man did make a mistake. He's been what I would consider probation for about the last 2 years. He's been on a tether, he's been on bond. He's done everything this court has asked him for. You heard the facts of this case. It was obviously not felt malicious enough by a jury to convict him on the original charges. Mr. Thurman knew that he did something wrong. He knew that it wasn't his best idea, but he didn't mean any maliciousness by it. He just didn't understand. Alcohol, young hormones. He's taken full responsibility. He sits before you awaiting your sentence. I'd like you to take into account, I apologize, Your Honor, it's hard to breathe in this thing. I'd like you to take into account, first of all, that he has been on what I would consider probation for about 2 years. No violations, has done everything that he said he was going to do. He's done it, he's faced it. He didn't run from the situation. And when it came time to settle out, he fully admitted to it. You know, he felt what he did was wrong to an extent. He's apologized, he's willing to move on. He wants to get this over with too, because this has taken up about 2.5 years of his life as well. So I ask that I don't feel any jail time at this point is appropriate. And, you know, the 36 months probation, I'll leave to the discretion of the court. However, I would ask that you keep into account everything Mr. Thurman's done over the last 2 years.
All right, thank you. Now, if you'd slide the microphone over to your client, please. And Mr. Thurman, is there anything you wanted to say?
I would like to say I apologize for affecting her life in the way I did. I really am sincerely sorry for what I've done. I take full responsibility for all my actions that I've done. I understand that it's been hard to going on almost 3 years with this situation that's been going on. All I can possibly say is that I'm sorry. I know sorry is not good enough. It won't be able to rewind time or change my actions, but I am very sorry.
All right, thank you. Well, you might be very sorry. I'm very disappointed because when I read your description in the pre-sentence report, it sure didn't sound like very sorry to me. It sounded like I didn't really do anything. let me make something really clear, because Ms. Gatgatru said a word that really struck me as like the word of the day here for you, and that is accountability. Accountability, I think, is so important here, because when I read your statement in the pre-sentence report, it doesn't even sound anything close to a crime. And yet I put you under oath and I took your plea and you gave me a sufficient factual basis here. So let's talk about what the crime is here. She was to the point intoxicated that she was incapable of telling you yes or no. And we know that those are the facts of the case. And you've turned this into some kind of a drunken orgy, and it wasn't that at all. She was helpless. She was not capable of telling you no, and it's not a crime to have sex with a drunken person. It's not. But when that person is unconscious, when that person is not verbal, when that person is incapable of expressing anything, then that is a crime. And you seem like, in a lot of ways, a decent guy with your background and, everything I read in here about your life, and you have no record. You seem like a decent guy. So what does a decent guy do in that situation? A decent guy watches out for her. A decent guy is protective of her or anyone in that situation. A decent guy doesn't swoop in and take advantage of the situation and force sex on a woman who can't say no. So, I'll say one thing, I do think that it was out of your character, because I don't see that in everything that I read about you. I do think it was out of your character, but it was so wrong, and there's no sentence that I can give you that will take away or really account for the pain, the suffering, the humiliation, everything. The list of words is endless that she went through, first during the night of the event, the days following, the weeks following, the years following, and then the trial where she had to testify about it. And, juries don't get hung because they don't find maliciousness. They didn't have to find maliciousness. I don't know why they got hung, but it wasn't that they felt it wasn't malicious. Your actions that night were intentional and inexcusable. And, you are capable of better. And I can see that, and you should have done it that night, because now there's nothing I can do to erase her pain. And, sorry today is nice. I will say it is nice that you could say that, but that doesn't erase her pain either. And neither will this sentence with sentencing guidelines of 0 to 6 months, which is the maximum that I could give under advisory guidelines. And if I'm putting you on probation, I can't even give you the full 6 months, really. So, she made another good point, and that is, the charge now and the guidelines now are nothing compared to what you originally had. And I think you should consider yourself very, very lucky that you ended up with this arrangement, because, a second jury, it could have been much worse. And actually, the chances are, and the statistics show, that with a second jury, it probably would have been much worse. But I think that, again, there's nothing I can do sentence-wise that will do what Ms. Gatgatru wants, and that is to take this account for her pain and suffering. But I do think that there is a sentence that is required for impact purposes, and at the same time recognizes that you have many good qualities, that I think this was out of character for you. I don't see you as going out and doing this again, but there still has to be accountability for what you did that night. And for those reasons, I am going to grant your petition for treatment under the Holmes Youthful Trainee Act. and I am going to place you on probation for a period of 18 months, 90 days in the Ingham County Jail with credit for 2 days served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $180 payable at the rate of $10 a month, costs in the amount of $500 based on the State Court Administrative Office calculated average cost for criminal case in Ingham County. Additional conditions of probation are, you may not use or possess alcoholic beverages, or be in bars, or possess any controlled substances or drug paraphernalia or medical marijuana. You must comply with both drug and alcohol testing as your agent directs. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You may not change your residence unless you first get written permission from your agent. You may not possess a weapon while you're on probation. You must comply with all the written and verbal orders of your agent. Let the agent into your home at any time. Submit to a search of your person or property without need of a warrant. Report any changes to your agent within 24 hours. No contact with Marissa Gottgetru either directly or through another person. You may not be within 500 feet of her residence, school, or place of employment. And you must make genuine efforts to find and maintain employment a minimum of 30 hours per week. And Mr. Thurman, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. And if you're making a request for one, you have to make it within 42 days of today's date. It explains that more on the form that you are now receiving.
And I confirm that he's received that.
Thank you very much. And you are remanded to the custody of the sheriff.
Your Honor, one more thing I'd like to add. Mr. Thurman just started a new job. Is it possible to get work release during the 90 days?
No,
So then-
it's not actually, for a number of reasons, but one of them being that that presents a real issue these days for the jail with the COVID crisis and people going in and out. So the answer is no.